Hi, I'm Wayne Sumner, Chair of the Policy Briefing Committee, whose report on end-of-life decision-making is the subject of this session. In these opening remarks, I will outline the work of our committee and set the stage for the discussions to come later in the session. So first, a little background. We go back to 2011, when the Royal Society released a report by an expert panel whose mandate was to survey the current state of end-of-life care in Canada and to make recommendations for future developments. In its report, the expert panel covered the full range of end-of-life care, including such important areas as withdrawal of life-sustaining treatment, palliative care, advance directives, and what we now call medical assistance in dying, or MAID. The mandate of our committee was threefold. First, to track subsequent developments in all of these areas in the 9 years since the expert panel report. Then, to assess the extent to which the various recommendations made by the expert panel have since been implemented. And finally, where appropriate, to recommend further steps toward full implementation. Now, there was way too much in our report to summarize all of it for this session. Anyone seeking a thoroughly researched study of the current state of end-of-life care in Canada is invited to consult the full report, which is available on the Royal Society website. For this session, we will be focusing primarily on just one part of our report, the part dealing with MAID. We do this partly because we think this is the area most likely to interest our audience, but also because it's the one in which there have been the most significant developments since the expert panel report, developments which continue today. As a reminder of what has happened, a short chronology. November of 2011, the expert panel report comes out just as arguments begin in the trial court in Carter v. Canada, the case that raised a constitutional challenge to the criminal code provisions that at the time prohibited medically assisted dying. June 2012, the following year, the trial judge announces her decision striking down those provisions as violating the Charter of Rights and Freedoms, and in her judgment, she cites the expert panel report. At that point, the inevitable appeal process begins that will eventually culminate at the Supreme Court. During that appeal process in June 2014, so this is now 2 years on, the Quebec National Assembly acts on its own by passing Bill 52, legalizing MAID in that province. In February 2015, the following year, the appeal process ends when the Supreme Court unanimously affirms the trial judge's decision. At that time, the court gives Parliament 12 months to enact a charter-compliant law providing access to MAID, and that period is later extended to 16 months. In June 2016, the end of that 16-month period, Parliament passes Bill C-14, which is still the current law governing MAID across the country. Now to return to our committee's mandate. The expert panel did much more in its report with respect to MAID than simply recommend legalization. It also developed a carefully thought-out policy for access to MAID. The various components of that policy were the subject of 10 of its overall 31 recommendations. So, with respect to MAID, the question for our committee was, how well do the Quebec and federal laws measure up to these recommendations? Our finding in a nutshell: they are a good start, but in some crucial respects, both laws provide a much more restrictive regime for MAID than the expert panel recommended. Here are some of the key restrictions. Both laws impose a minimum age of 18 for eligibility for MAID, thereby excluding mature minors. Second, both laws impose a mandatory waiting period between approval for MAID and its provision. Third, both laws make no allowance for advance requests for MAID. Fourth, in order to qualify for MAID, Bill C-14 requires that the patient's natural death must be, quote, reasonably foreseeable, end quote, while Bill 52 requires that the patient must be, quote, at the end of life, end quote. Both laws therefore exclude some patients with serious and incurable but chronic illnesses. Fifth and last, both laws effectively exclude patients whose sole or primary medical condition is mental rather than physical. So the conclusion of our report with respect to MAID, all of these restrictions would need to be removed in order to fully implement the recommendations of the expert panel. That's just a very quick overview of the issues we look forward to discussing in this session. My three colleagues on the committee will have much more to say on at least some of them in their remarks. Meanwhile, I'll close by thanking you for your attention, and I will see you later in the live Q&A.
My name is Jocelyn Downey, and I'm the James Palmer Chair in Public Policy and Law at Dalhousie University. More importantly for today's session, though, however, I was a member of the 2011 Royal Society of Canada Expert Panel on Physician-Assisted Dying. My role today is to continue to take you along on the journey, and my part of the journey is to take you from Bill C-14 to C-7, with some stops at the Lamb decision, the Truchon decision, the Council of Canadian Academies expert panel reports along the way. So the first stop is Lamb versus Canada. Now, 10 days after Bill C-14 was passed, the very same legal team from Carter was back in court arguing that the reasonably foreseeable eligibility criterion violates the Charter. Julia Lamb is a young woman with a degenerative neuromuscular disorder who would have been thought not to be eligible for MAID. Her natural death would not be found to be reasonably foreseeable, and so she was challenging C-14. Surprisingly, the Attorney General's expert indicated that Julia would be eligible whenever she expressed a, quote, certain intent to refuse life-sustaining treatment, unquote. In her case, this would be a BiPAP machine that helped her breathe at night and prevented pneumonia, which, if untreated, would kill her. So as a result, her case was adjourned. So it actually didn't end up changing anything with respect to where Canada was in relation to the Royal Society of Canada expert panel's recommendations. But the next stop did change things, and this is Truchon versus Canada and Quebec. In this case, two people with significant disabilities made charter challenges to C-14 and to the Quebec MAID legislation. And they argued that the reasonably foreseeable from Canada and the end of life from Quebec, those eligibility criteria breached their rights under the Canadian Charter of Rights and Freedoms. And Justice Baudouin agreed that these eligibility criteria breached the Charter, and she struck down reasonably foreseeable and end of life, thus moving Canada's MAID framework closer to the RSC panel's vision. Now, the next step on the journey is the Council of Canadian Academies expert panel reports. The federal government, following a requirement set out in Bill C-14, had commissioned an independent review of three outstanding issues that were too complex or to deal with, or that they wanted further consideration on. And those were requests for MAID from mature minors, requests for MAID made in advance of loss of decision-making capacity, and requests for MAID where mental disorders are the sole underlying medical condition. Now, the expert panel provided very useful reviews of the clinical, legal, ethical literature, both here in Canada and abroad, but they made no recommendations about policy. So again, there was no further movement toward the RSC panel vision. Now, the final stop is C-7. And C-7 is in front of Parliament as we speak. The government has introduced proposed amendments to Bill C-14 in response to two things. In response to the Truchon decision, which struck down reasonably foreseeable as an eligibility criterion, and also in response to a massive public consultation that was conducted last winter with over 300,000 responses to an online questionnaire. This is the largest response ever. So in C-7, what did they do? Well, the first thing they did is remove reasonably foreseeable as an eligibility criterion. C-7 also introduces a blanket exclusion of persons with mental illness as their sole underlying medical condition. And it establishes two tracks with different procedural safeguards. And which track you are on depends on whether your natural death is reasonably foreseeable. So reasonable foreseeability is not an eligibility criterion anymore. It's not an absolute barrier to access, but rather it determines whether you're on track 1 or track 2. And the key track 1 amendments, so this is where natural death is reasonably foreseeable, are the following. Removing the 10-day waiting period between the request and the provision of MAID, reducing the number of witnesses required from 2 to 1, permitting a final consent waiver. So through this, before you lose capacity, you can set a date on which you want to receive MAID at some point in the future. And it permits advance requests in anticipation of failed self-administration, because in Canada you can either have provider administration or self-administration, but if the ingestion fails for self-administration, a clinician can give you the injection because of this amendment to C14. The key track 2 amendments, so this is where natural death is not yet reasonably foreseeable, are the introduction of a 90-day waiting period between the request and the provision of MAID, a requirement that the person seeking MAID must be offered consultations with relevant professionals for services and care related to their condition, and the provider must get a written opinion from someone with expertise in the condition causing the person suffering if they do not themselves have that expertise. So then we can ask, what has been the progress towards the Royal Society of Canada panel recommendations since C14? Well, a major one is the removal of the eligibility criterion, end of life, for Quebec and reasonably foreseeable for Canada. The removal of the 10-day waiting period, where natural death has become reasonably foreseeable, and allowing some advance requests where natural death is reasonably foreseeable and in the case of failed self-administration. But what then are the steps that are still required in order to meet the Royal Society of Canada panel recommendations? Well, it would be to allow access through advance requests where not yet reasonably foreseeable, to allow access to mature minors. These are individuals under the age of majority who have the capacity to understand the nature and the consequences of a decision to request MAID. It would be to remove the mental illness exclusion that was just introduced in C7, to remove the 90-day waiting period, and to introduce a National Oversight Commission. So the bottom line of this part of the journey is that there has been some considerable progress towards the Royal Society of Canada expert panel recommendations, but we are not all the way there yet. So I leave you now to proceed to a deeper dive on a couple of specific issues. And the 2 clinician members of our policy briefing committee are going to talk about MAID where mental disorder is the sole underlying medical condition, and palliative care and MAID.
Hi, my name is Gupta. I'm a psychiatrist and associate professor at the University of Montreal. I'm also a researcher in ethics and the philosophy of psychiatry, and I've been working on assisted dying for the last several years. I was very glad to be part of the Royal Society's Policy Briefing Committee on End-of-Life Care and to be part of the panel today. I'm going to speak about one issue that we touch on in our report: medical assistance in dying for persons whose mental disorder is their sole underlying medical condition. It's a bit of a mouthful to say, so throughout my remarks, I will simply say MAID for mental disorders. So why is it important to talk about this topic right now? In September of 2019, a Quebec Superior Court decision found that one of the eligibility criteria that a person had to fulfill to receive assistance in dying, that one's natural death is reasonably foreseeable, or in the language of the Quebec law, that the person is at the end of life, violated the Canadian Charter of Rights and Freedoms. The decision did not take effect right away because the Canadian government asked for time to make changes to its original law. However, on December 18th of this year, the eligibility criterion of natural death that is reasonably foreseeable will no longer be a requirement for receiving assistance in dying. The federal government has prepared a bill to respond to this court decision, and the bill is working its way through Parliament at this very moment. One of the changes the bill makes compared to the original law is to introduce a specific clause that excludes people whose mental illness is their sole underlying condition from being able to make a request for assisted dying. Now, neither the Canadian nor the Quebec laws ever excluded people with mental disorders. However, the fact that a person's natural death had to be reasonably foreseeable meant that most people with mental disorder as their sole underlying medical condition were unlikely to be found eligible. This is a complicated and controversial topic. 3 years ago, the Council of Canadian Academies was asked to convene an expert panel to study this topic, However, after over a year of careful study, the panel remained divided even on how to interpret the key issues. So why is this topic so controversial? The federal government, and indeed many people, believe that there is something fundamentally different about mental illness compared to other kinds of illnesses. This difference means that it would be harmful to allow the practice, and this is what justifies excluding such people. What are these differences? First, some worry that people with mental illness are not legally capable to make such a serious decision. In general, all adults are considered capable as a default position. The MAID laws require that clinicians go further and establish that a person is capable to consent to MAID. As a practicing psychiatrist, I agree that in some cases it can be very challenging to figure out if a person should be considered legally capable. And to be sure, if different psychiatrists meet with the person, they might disagree amongst themselves. But this doesn't explain why MAID should be disallowed in all cases. Others worry that the evolution of mental illness, what we call prognosis, is much less predictable compared to physical illness. Now, it is tempting to say that because of the finality of MAID, we should not act unless we are 100% certain. But outside the context of end of life, prognostication becomes much more difficult for many conditions, including many physical illnesses. Uncertainty about prognosis, then, is not limited to mental illness. Finally, we know that people with mental disorders are at higher risk for committing suicide than the general population. Indeed, wanting to end one's life can be a symptom of some mental disorders. Would allowing MAID for such persons somehow be a way of facilitating or even condoning suicide? This is an active debate amongst psychiatrists, researchers who study suicide, and ethicists. We confront similar issues when, for example, someone with a mental illness wants to discontinue a life-sustaining treatment, which legally they are allowed to do. One of the things that I find most puzzling is this. If the bill passes, a person who has had a severe mental illness for decades, who has tried many treatments without success, and who is suffering terribly, will not be permitted to ask his doctor if he could be eligible for MAID. But this same patient with the same mental illness, who just also happens to have a chronic physical condition, would be permitted to request MAID. There are many subtleties on this to explore on this topic, and I look forward to addressing some of them in the question period.
Hi, my name is Joshua Wales. I'm a palliative care physician and MAID provider at the Sinai Health System in Toronto. Thanks to the Royal Society for inviting me to speak today. Today I'll be discussing the relationship of palliative care to medical assistance in dying. I'll talk about some reasons for the official rejection of MAID by the field of palliative care and my own responses to these objections. I'll talk about some associated challenges and then some possible ways forward. So even before MAID was legalized, the Canadian Society of Palliative Care Physicians rejected any involvement in MAID. This is a statement from 2015, which explicitly stated that palliative care does not include MAID. One of their primary objections is related to one part of the definition of palliative care, which states that palliative care does not seek to hasten death or intentionally end life. But I and many of my colleagues would argue that exclusion of MAID based on historical definitions ignores the fact that all fields of medicine must continuously evolve and definitions can change. Indeed, no medical specialty includes hastening death within its definition. And if we agree that MAID is potentially in the scope of practice of every medical specialty, which it is, including but not exclusive to palliative care, it follows that definitions must change for all of us, including palliative care. That brings us to the next objection, which is the concern around society conflating palliative care with MAID, assuming that palliative care, because of its proximity to death, will take on the provision of all MAID. This, I agree, is a valid concern. It's often assumed by other specialties that I, as a palliative care physician, am the de facto MAID provider, which is incorrect. But the solution to that is not to exclude palliative care from being involved in MAID, but rather to remind the entire medical community that MAID is our collective responsibility. No single specialty owns MAID, and neither should any single specialty unequivocally reject it. Many also worry about attaching the stigma of MAID to palliative care with the assumption that should palliative care clinicians and settings begin offering MAID, are people going to refuse palliative care because they're afraid of or object to MAID? However, it might be argued that the opposite is also true, that patients with palliative care needs who want the option of MAID may avoid residential hospices or palliative care units or engaging with palliative care altogether for fear that MAID won't be available to them or for fear of moral judgment should they request it. To the next point, some also worry that requests for MAID may be indications of suffering that could be ameliorated by palliative care, and that no one should choose MAID based on a lack of access to palliative care. And I agree with this 100%. What has been noted, however, in many contexts, including in the most recent report on MAID issued by Health Canada, is that the most prevalent symptoms for which patients request MAID are existential. Loss of autonomy, loss of ability to engage in activities, loss of independence. And these are symptoms which are notoriously difficult to palliate. While there are certain modalities and approaches that I use every day to varying degrees of success, they're not perfect. Palliative care is not a panacea, and MAID deaths are not a failure of palliative care. Data also suggests that difficulty accessing palliative care is not driving requests. So 82% of patients who receive MAID did also receive palliative care, acknowledging that we don't have good data regarding the quality or quantity of that care. And for the 16% of people who received MAID who did not receive palliative care, it was accessible for almost 90% of them. So it doesn't appear that people are choosing MAID because of a lack of access to palliative care. So we discussed some of the reasons for this official separation of MAID and palliative care, but what are the issues that this separation creates? So most commonly, it creates a problem of access, where patients are receiving palliative care in a palliative care unit or a hospice or a hospital, and they're forced to transfer to a different non-objecting facility. It's worth noting that many facilities disallowing MAID are faith-based, which is an issue when faith-based facilities provide such a large amount of the palliative care in Canada. Oops, sorry about that. For example, in Alberta, Covenant Health provides 1/3 of the palliative care beds there and refuses to allow MAID. And in Ottawa, for example, the Breffage Hospital is the key deliverer of palliative care and also disallows MAID. I would argue that this amounts to a cruel system whereby the institution-centered principles prohibiting MAID take precedence over principles of patient-centeredness and autonomy, which are also palliative care principles. While I certainly respect an individual clinician's right to conscientiously object, it becomes more dangerous to patients when an entire publicly funded facility conscientiously objects. And while some health authorities have required that palliative care settings provide MAID in their palliative care settings, such as in the case of Fraser Health in BC, there has been considerable pushback. One hospice, which faced a funding cut due to its refusal to allow MAID, is challenging that loss of funding. All that said, despite the official opposition of the palliative care community to MAID, in Canada, 10% of MAID cases are performed by palliative care physicians, and 20% of cases do still occur in palliative care facilities. So what are the solutions? So clearly there needs to be new guiding principles which allow the peaceful coexistence of objecting individual palliative care providers while also supporting patients receiving palliative care who desire MAID. I think we should start by acknowledging that, yes, MAID does not exclusively belong to palliative care. It is the collective responsibility of every medical specialty and depends on the most appropriate context that a patient finds themselves in. That said, if a patient is receiving palliative care in a palliative care setting, it must be available to them. This is consistent with the value of patient-centeredness and autonomy. And while there should always be allowances for conscientious objections of individuals, it should not extend to publicly funded institutions. And this extension creates significant problems of access to patients who are required to transfer facilities. So I'll end there. Unfortunately, I'm not available today for any questions, but feel free to email me if anyone wants to discuss this further. And I thank you for your attention today.
Thank you again to all four of our panelists for taking the time to record those videos to bring everyone up to speed on what's happening. So as I mentioned at the start, we're now going to be joined live by Wayne and by Mona for a Q&A session, excuse me. We have about half an hour for that. So again, to audience members, if any of you have any questions you'd like to ask, just go ahead and put them in the chat, direct them to me. I do have a couple of questions that have already come in, but I'm just going to start with something a little bit more general for Wayne, if I can. And that is, I wonder if you can just sort of peer into your crystal ball for me and tell me what you think is going to happen next with MAID as the debate over C7 heats up. Where are things going now?
Okay, thanks, Kelly. Jocelyn and I, and well, all four of us really tried to sort of sketch what the process has been so far. So the Bill C-14 was passed in June of 2016. So we're already 4.5 years on from that. And I think two things, leaving aside the sort of specifics, two things have really become clear. First of all, designing an adequate regime for legal access to something as important as MAID is very, very difficult. The issues are very complicated. There are no easy answers to them. And secondly, because of that, we need to think of this, the evolution of a MAID law in Canada as a work in progress, as a process rather than an end state. So we know where we've got to so far. The principal changes in the law are those that are embedded in in Bill C7, which is now currently before Parliament. So that the next stage will be C7 being passed either in its current state or with possibly with some amendments. But it's not going to end there. I don't think we'll have a settled policy in this area for probably as much as 3, 4, 5 years down the road, maybe not even then. I can see it constantly evolving. This is what's happened in other jurisdictions around the world. It's hard to get this right the first time, and you want to get it right because the issues are so deep and so important. So once we're past C7, then the ball will be in Parliament's court again because of the mandatory 5-year reviews that were written into C14. And they will cover 3 of the most contentious issues: whether MAID should be available for mature minors, whether it should be available to patients whose sole underlying medical condition is mental rather than physical, and whether it should be possible to access MAID through the use of advance requests. Now, as far as I know, there's no current schedule for those 5-year reviews getting underway. They were supposed to start last June. That was the beginning of the 5-year period from 2016. But everything's on hold because of COVID, so we don't know exactly when those reviews will get underway, and we certainly don't know what the outcome will be. So that's going to be the next significant stage. But even after that, I think we shouldn't assume that that just completes the process. This is going to be an ongoing process, I think, for some considerable time to come, and should be, because the issues are so important.
You mentioned about of those sort of 3 areas that the legislative review is supposed to look at. You mentioned advance requests. I have to say the questions that are now popping up in my chat bar are all about advanced requests. So can you speak a little bit about that and tell us where we're at legally on that question in Canada?
Okay. Well, where we're at legally is neither C14 nor Bill 52 in Quebec made any provision for advance requests. As I mentioned in my remarks back in 2011, the expert panels explicitly recommended that advance requests for MAID be possible. I find the exclusion of the possibility of advance requests for MAID a little anomalous. I should mention that a very minor provision is embedded in C7. So it will be possible that once C7 passes, for someone who has already been approved for MAID to execute an advance request that MAID be provided, should they happen to lose capacity between the approval stage and the provision stage. But that's a very minor movement in the direction of advance requests. The much more important steps would be to allow a patient to execute an advance request for MAID after diagnosis with a serious and incurable illness, should they then lose capacity after the diagnosis stage, or even beforehand, anticipating that you might someday develop a serious illness that compromises your decision-making capacity, execute a request in advance that MAID will be provided under those conditions once you've lost capacity. Those are the much more serious steps. And I think the only other thing I want to say about this is there's a kind of legal anomaly here, because advance directives that refuse life-sustaining treatment in the event of loss of capacity have been legally recognized in this country for some time, and the Supreme Court reaffirmed their validity in its Carter decision. So it's possible for me right now, if I'm worried, for instance, that I might end up in the later stages of Alzheimer's some way down the road, to stipulate that I refuse certain kinds of measures that would keep me alive, that would sustain my life. That will hasten my death if that refusal is acted on. But I can't, at the same time, same stage, indicate that my request is for MAID under the same conditions. So I think it's anomalous that I can be allowed to die through non-treatment should I end up, for instance, seriously with serious dementia, but I can't have MAID provided for me at that time. So that's basically where we're at with advance requests. And I think that's obviously one of the issues that's going to have to be sorted out. I can't imagine continuing prohibit advance requests for MAID. It just makes no sense.
I wonder, Mona, if I could maybe get you to weigh in on that subject as well, what you see happening with the question of advance requests.
Well, it's certainly something that's on the minds of Canadians. And as far back as the public consultations that were held in Quebec concerning its law, which happened in the early 2010s, so around the time of the Commission for Dying with Dignity, that was the question, that was the main question on the minds of Quebecers even then. And just to add to what Wayne has said, the government of Quebec did in fact convene its own expert panel on the question specifically of advanced requests after the coming into force of its law. And it also recommended that advance requests be possible in certain circumstances larger than what has been recommended in Bill C-7. So it's obviously an issue that's very much on the minds of the population. And I think Wayne is absolutely right to say that it's inevitable that governments are going to have to think through this from a public policy point of view.
Mona, if I can stick with you for a minute, if I understand it correctly, you know, unlike this question of advance requests, the question of MAID for mental disorders, the government has actually gone out of its way in writing C-7 to specifically say, we want to ban that. We don't want to allow, we want to proactively say we do not want to allow MAID for people whose only underlying condition is a mental illness. So I wonder if you can talk a bit about what you think of that move by the government to take this category and say, we're putting it off the table.
Well, Kelly, I'm not in the minds of the people behind the clause, so I cannot tell you exactly what their motivation or motivations might be. I can certainly tell you what government officials have stated the motivations are. I think that there is a worry that the issues involved are complicated and that more time is required to think through them, to develop appropriate policy concerning them. The government has at the same time also issued a statement in which it says that, look, excluding people with mental illness is justified under the Charter of Rights and Freedoms. So I think that's those are two messages that are a little different. If you see the distinction, on the one hand, yes, this is something we might do in the future, we just need to think about how to do it, versus, well, it's not inconsistent with the Charter, so we're not actually sure whether we need to do this in the future or ever reconsider these questions. You know, and I explained a bit about this in my statement, and we can discuss it more. There are clinical reasons that the government has advanced that they say means that people with mental illness as their sole underlying condition should be excluded. And so that's, I think, going to be part of the debate now and going forward, whether these clinical reasons truly apply only to people with mental illness, and if they're sufficient to justify a complete exclusion.
What is the psychiatric community's view on this question?
Yeah, that's a great question. I mean, like physicians in general, as my colleague Josh Wales mentioned in his presentation, and like Canadian society overall, the views of physicians are evolving over time. And so at the moment, the two major associations that represent psychiatrists in this country, the Canadian Psychiatric Association and the Association des Médecins Psychiatres du Québec, have both argued that people with mental illnesses should not be subject to a blanket exclusion. On the other hand, the Canadian Medical Association reports that its members, which include all kinds of doctors, not just psychiatrists, remain divided on the question, including those doctors who are active as MAID assessors and providers right now. So we see that there are a range of views. And actually, I would go further, Kelly, and say that there aren't just people who say, yes, it should be allowed, and no, it should not be allowed, but there are those who might say, yes, in these circumstances only, no, unless it's that circumstance. So there might be a whole range of specificity in the middle there amongst physicians. But I think it is worthwhile to note that now, compared to 4 years ago, the two major psychiatric associations are saying, a blanket exclusion, at least, is not the right direction to go in.
Okay, Wayne, if I can turn back to you for a moment here. I wanted to ask you specifically about this question of reasonable foreseeability. That's really, I think, what's at the heart of what's happening with C7. It's responding to this Quebec court decision that struck down the reasonable foreseeability clause. Some of the groups that have been opposed to the changes proposed in C7 have been primarily composed of folks representing people who have chronic disabilities. And one of the things they have argued is that to take away the reasonable foreseeability clause is really to sort of downgrade the value of the life of somebody who has a disability. And of course, the two people at the center of the Truchon decision, the Quebec decision, were themselves sort of chronically disabled and wanted access to MAID, even though they weren't close to the end of life. So Wayne, can you just talk about, from a philosopher's perspective, what you think about this move to take reasonable foreseeability out of the law in response to this decision?
Okay, a couple of thoughts. First of them, not particularly philosophical, but just a sort of comment on where the disability community has been with respect to MAID. It's certainly true that there is a sector of the community that has expressed very strong opposition, especially to expanding MAID to chronic conditions, including lifelong disabilities. But it's also noteworthy that just about everyone who has stood up and advocated for legalized MAID in this country, all the way back to Sue Rodriguez, has been a member of the disability community. The disability community has been front and center in advocating for legal MAID, and that was also evident in the Truchon decision. It's a complicated issue. I guess the main thing I'd want to say about it, well, first of all, I should point out, Jocelyn mentioned that what C7 establishes is a kind of two-track process for accessing MAID. If your natural death is not reasonably foreseeable, then you're on the slow track. The fast track has eliminated even the 10-day waiting period, but the slow track is pretty slow. So if you fall into that category, for instance, because your condition is a disability in which death is not imminent or reasonably foreseeable, then the process of approval for MAID is a 90-day process that includes the requirement that you receive counseling and that an opinion be sought from an expert in your particular condition. So if the worry is, and it often seems to be the worry, that persons with disabilities will make sudden or impulsive decisions to access MAID in the way in which decisions for suicide are often very sudden and impulsive, that simply is incompatible with the process that's been established under C7. But I guess the broader point I'd want to make, and this is getting a little more philosophical now, is that there's no reason to think that persons with disabilities are less able to make fully informed and fully autonomous decisions about how their lives will go and how their lives will end than persons without disabilities. And what eliminating or partially eliminating the reasonably foreseeability condition provides them with is the same range of choices that individuals with other medical conditions have. And if anything, I would think it's discriminatory to deny them that same range of choices.
Mona, can I ask you to weigh in on that as well? Do you have thoughts on that question?
Yeah, I mean, I think I would sort of pose the counter to what Wayne has just said, and I actually think that these same arguments can be had about persons with mental disorders. You know, I think that you have groups that, as a group, as a collectivity, experience certain vulnerabilities, whether those are social vulnerabilities, economic vulnerabilities, etc. And then you have individuals within that group who are saying, well, regardless of the vulnerability of the group, I myself want to be able to make a decision as an individual. In fact, I myself might not even consider myself to be vulnerable. And in fact, I may not be vulnerable, and I want to be able to make that decision. So I think the challenge for the policymaker is, what do you emphasize? Do you emphasize the characteristics of the group and say, well, even though an individual in the group wants something, we're going to say no to protect the group as a whole? Or do you say, as Wayne has suggested, well, no, regardless of the impact on the community, we're going to go ahead with what the individual wants, provided, of course, that individual fulfills the criteria and so on. You know, and interestingly, Kelly, I think in part this is an empirical question. Because I think that if you do allow assistance in dying, say, for a group that is considered to be vulnerable, you can actually follow what happens to persons who belong to that group, to society's beliefs about that group, to whether persons with those conditions experience more pressure than others, and establish whether there has been a damaging impact on that group or not. But of course, that requires you to allow the practice. And I understand that there are groups and communities who say even to allow it to gather that data would be dangerous to their community.
All right, I'd encourage everybody in the audience. We have about 10 minutes left for the Q&A. So if anybody does have any other questions, please send them my way. In the meantime,
can I just add something to what Mona had to say there? Because I think there's a larger lesson here. And it applies to the inclusion of persons with mental illnesses, and it applies to right across the board, to allowing advance requests, to eliminating the reasonably foreseeable condition. I think one of the lessons in this is, well, two lessons. One of them is there are always going to be difficult cases, and something as important and crucial as end-of-life care, especially MAID. There are going to be hard cases where we're not exactly sure, you know, what the right answer is. And there are two ways of responding to hard cases. One of them is to try to eliminate them. And you eliminate them by imposing a blanket exclusion. So the elimination of mental illnesses as the sole underlying condition. You'll have hard cases once you allow persons with mental illnesses to try to access MAID. So how do we get rid of them? Well, just eliminate the whole category. And the same holds for advance requests. There will be hard cases of advance requests. Those aren't easy issues. They're very complicated issues. So how do we prevent that? Okay, we'll just eliminate the whole category. But I think it's pretty clear by now that that's not the best way to proceed. That used to be the way in which the government treated MAID itself. There will be hard cases here. How do we exclude them? Okay, we won't legalize it at all. That's basically what happened back when the Rodriguez decision was made in 1993. And now we've moved on from that to thinking that, well, maybe that's not the best way to respond to difficult issues and hard cases. Maybe the better way to respond is to open it up at least a little and trust the process. Trust the process on an individual level. You know, I think that Mona made a very important point about thinking about it at the group level or thinking of it at the individual level. But not all individuals are the same. Not all individual members of a group, such as the disability community, are the same. There are processes in place that involve the patient, that involve the provider, that involve the assessor. There are controls and safeguards in place as well. So maybe the better way to go on most of these issues is to open up the possibility of access and allow the hard cases to be dealt with on their own as they come up as individual issues, rather than simply falling back on a reflex group exclusion.
Okay,
Like,
thanks a lot.
can I just add
Sure,
one
go
thing
ahead,
to that? This is terrible because Wayne and I are just doing ping pong, but
Yeah.
I just, what I would add as a psychiatrist is simply that my worry, one worry that I have about the exclusion clause is that it creates what I believe to be the false impression that everything that concerns physical illness in MAID are easy cases, as Wayne would say, and everything that concerns mental illness in MAID are hard cases. And I don't think that's true. And I think physicians who have been involved in MAID practice would say there have been plenty of hard cases that have arisen as a result of physical disease. So that's simply a misperception that could emerge in the minds of people because of the exclusion criterion.
Yeah, I think that's absolutely right.
And I think one of the areas of hard cases would obviously be dementia and Alzheimer's advance request cases. I want to bring it back to that just because that is the thing I'm getting questions about in the chat box. And I have to tell you, in my reporting, it is the subject that I get the most questions about. It is the subject readers have the most interest in. And I think it's fairly safe to say that there is a substantial appetite in the Canadian public to have access to this. Wayne, can you tell me what you think it is that makes this type of situation a hard case, and why it is that, like, the government has just so far refused to open the door to this?
Sure. I mean, I'll start by saying it's not only a hard case here, it's a hard case in the few jurisdictions. Well, there's really only one jurisdiction that allows access to MAID through an advance request, and that's in the Netherlands. And there have been some very hard cases there, real head scratchers. I understand it. I think it's easy to understand the appetite for it. I mean, I share the appetite for it. You sit at this point in your life when everything's going just fine. You maybe have had some experience of a relative, maybe even a parent, succumbing to the later stages of Alzheimer's, and you absolutely do not want ever to have to go through that. You want to have some control over terminating that process at some point. What's the means of control? Well, something you can do now in order to stop the process later, and an advance request for MAID is the ideal mechanism for doing that. But I don't want to make it sound as though this is simple. I don't think it is. I think this is the most complicated of all of these issues, and more complicated than the one that Mona is expert in. Sorry, Mona.
My thing's more complicated than yours.
And I think part of one of the complications is that a disease like Alzheimer's progresses slowly and gradually. And it's very difficult to stipulate, especially to stipulate in advance, the point in the process at which you want the request for MAID to be triggered. And there's always a conflict, or a possible conflict, between the condition you're in at that time, I mean, how things are going for you at that time, and the advance request. So you might, for instance, stipulate that when I can no longer recognize my family, when I've got to the point where I can't recognize my family members anymore, well, that's it for me. I don't really want to carry on. So you write that into your advance request. So you get to that stage when you can't any longer recognize your family. But in other respects, it doesn't look as though things are going that badly for you. You've still got very minimal life left, but it might be perfectly okay. It can become very difficult for a physician who knows about the advance directive to execute it in a situation in which you don't seem to be suffering at all, even though you've reached that trigger point. So one of the problems is the suffering condition. I mean, built into C14 and in legislation in other places like the Netherlands is a requirement that the person be experiencing intolerable suffering, suffering that they themselves view as intolerable. Well, how do you consult someone in the later stages of dementia to determine whether or not they find their suffering intolerable? Or how do you determine that they're suffering at all if they can't actually tell you? So I'll go back to the point I made before. If we do, as I think we should, allow advance requests, because I think all of the reasons for doing so are very good reasons, we should expect that there are going to be hard cases, and they're going to be difficult to resolve on a case-by-case basis. We shouldn't think that this is an easy or simple thing to do, but that also shouldn't stop us from doing it.
All right, Deb, we are down to 1 minute left here, so I'm going to give Mona the final word if I can and ask her if there's anything you'd want to add to that question about hard cases and advance requests.
Well, I just want to say that I really appreciate Wayne's comment, because I think it's very tempting as a society, it's tempting for the government, it's tempting for policymakers to think that they can come up with a simple solution or even a solution that is going to apply in all cases. And I think what I like about Wayne's contribution is that it forces us to confront the fact that we cannot find our way around every difficult problem with just one law or one procedure or one rule. We have to constantly be in a process of thinking and rethinking. And I actually think this Royal Society process is a great example of that. An expert panel that thought deeply about a question, and then a group that came back to rethink what they thought about. And hopefully this iterative process, if I can, will continue on, and this dialogue will continue within our society, because I think that is actually the only way that you arrive at any conclusion about hard cases.
All right, I think that's a great place to end it. Thank you so much for your time, Mona and Wayne, and to everybody who joined us today. I keep an eye on what's happening with Bill C7. I think it's going to be an evolving, interesting process. Thanks so much for your time.
Thanks everyone for participating.
Thank you all.